Hello, and welcome to an information security analysis of California's Data Breach Notification Law, SB or Senate Bill 1386, by Kara Bloom, Ryan Lewis, and Ernesto Rodriguez.
The first section we're going to be talking about today is the first section of any good information security policy, and that is the Statement of Management Intent. Now, it should be noted that this is a Senate bill, so it's not going to have a Statement of Management Intent that's officially labeled, Statement of Management Intent. Instead, what it's going to do is it's going to cover the most important sections of the Statement of Management Intent. It's going to tell you what existed, it's going to tell you what will exist, and it's going to tell you why management is making this new thing exist. So the first thing is existing laws, what existed in the past. Now, this is the maintenance and dissemination of personal information. This is keeping an accurate account of disclosures. It's requiring businesses to take all reasonable steps to destroy records. So these are the things that existed already. But what didn't yet exist is a requirement for companies and agencies in California to notify their users when their data is seen by an unauthorized party. So this new law, the what of the Statement of Management Intent, is that it would require a state agency, person, or a business in California that owns digital PII specifically to notify of any breach of security of the data to any resident in California whose unencrypted personal information was or is reasonably believed to have been acquired by an unauthorized person. So this is the what? This is the executive summary, the too long didn't read of the entire law. It's requiring a notification of disclosure in a certain specific circumstance. The next thing that's important for any Statement of Management Intent is why management is taking this action. And that is the privacy and financial security of individuals is increasingly at risk because more and more PII is being collected. It's being collected in all of these many various ways, and it's great source material for identity thieves. Then they note that identity theft is one of the fastest growing crimes committed in California, that it's costly to the marketplace, and that victims must act fast. So the goal of the Senate, which in this case is the management, is to protect Californian citizens from all of these various myriad identity theft issues. This is the Statement of Management Intent.
The second section of a good information security policy is the scope. The scope is addressed in Section 2 of the law, where it states that any agency that owns or licenses computerized data that includes personal information shall disclose any breach of the security if they have the data of any resident of California whose unencrypted personal information was or is reasonably believed to have been acquired by an unauthorized person. Now, this means that if you are operating in Pittsburgh and your entire company is in Pittsburgh, but you have the data of someone from California and you are breached and your information is unencrypted, you must report that breach in accordance to the California Data Breach Notification Law. So to continue investigating the scope, one of the words in this definition is personal information. They further go on to define what exactly they define is personal information. So personal information is an individual's first name or first initial and last name in combination with any of the following: social security number, driver's license number, your account number, debit or credit card number, pretty much any type of account number that can be used to access financial information. While this is a great attempt at addressing what personal information is, it's not all-encompassing. So they're addressing this small little circle here, this little facet of what it means to be personally identifiable information, while they should be addressing this much larger circle, which includes things like email addresses, phone numbers, your address, etc. One thing to mention actually is when this law was originally enacted back in 2003, there was a gap that is now actually being addressed. But if we go back and look at the definition, it says that data must be unencrypted. In the 2003 version, it does not actually define what it means to encrypt data, which is a gap in what they're trying to address. So when they amended this in 2016, they added a definition of what it means to be encrypted. So for purposes of this law, encrypted means to be rendered unusable, unreadable, or indecipherable to an unauthorized person through security technology or methodology generally accepted in the field of information security. So pre-2016, Julius Caesar, using his Caesar cipher, would have technically been able to get away with saying, yes, my data is encrypted, I've used my cipher. In 2016, Julius is no longer secure, his data is no longer encrypted according to this law, and he would have to report a data breach.
The next section of any good security policy is 3, the requirements. This is where we get to the actual text of what is going to be added to the civil code in California. It includes a lot of different important parts of any good requirements. The what, the when that triggers the what, the exception, when basically the what can be avoided, and a to-do. This is exactly what you're doing when the what is triggered. So first, the what. What is basically what we've all been saying. So any person or business in California with the unencrypted data, but it goes into a little bit more depth about the specifics. The disclosure shall be made in the most expedient time possible and without unreasonable delay, consistent with the legitimate needs of law enforcement. So this is talking about some really specific times. Well, actually, it's not very specific. That's the problem. Most expedient time possible. It says when you should enact your requirements, the disclosures themselves, but it doesn't give you a specific number of days in which to do that. Then it discusses when the requirements are triggered. For this, it means the breach of security, and it goes on to define how that is the unauthorized acquisition of computerized data that compromises the security, confidentiality, or integrity of PII maintained by that person or business. So they're being quite specific about when you're required to do stuff, when are you required to do it, when there is a breach of security. Now, they do give you one standardized, codified exception to the requirement, and that is that you can delay it if a law enforcement agency determines that the notification will impede a criminal investigation. So you don't get out of the notice, but what you do is you can delay it. Now, this is a great implementation of information security policy because it's a standardized way to get through the law, even though it's required, when it would actually impede the work of others. The last part of the requirement is the actual content of the breach notification. So there actually was no specification of exactly what needed to be said in the original 2003 version of the law. What they did have was how you can notify. That's a written notice, an electronic notice, or a substitute notice, which can be an email, a posting, or a notification to media. So it's quite clear about how you have to notify people, but it didn't tell companies or agencies how they were supposed to notify them specifically, which led to a lot of sort of avoiding the responsibilities included in this law. This is the new 2016 amendment to the law, and it goes way more in depth into exactly what companies have to do. They have to write it in plain language. They have to title it very conspicuously, Notice of Data Breach. They have to include specific types of information, what happened, what information was involved, what that company is doing, what that user can do, and a place to go for more information. These are very important sections that they noticed for the 13 years that the law was applied without this requirement, that companies basically weren't doing. They could just say, hey, in 6.5 at the bottom of their website or at the bottom of an email, there was a notice of data breach. But perhaps people weren't actually knowing about the data breach itself because they didn't have all of this additional information. California even provides this handy dandy worksheet just in case a company doesn't know exactly what they need to do after that laundry list. So if you're a company, you have to put your name, you have to put the date, you have to say that it is specifically a notification of data breach. They have to talk about what happened. They have to talk about what information was stolen. Maybe it's social security numbers. Maybe it's credit card data. And then they have to talk about what they're doing. Maybe they're just gonna throw a bunch of money at FireEye. Then they have to talk about what the person can do. How can you protect yourself? They might add a little bit more information, and they have to give you somewhere to go. But there's a big gap with this sheet in particular.
It's wonderful that they've provided such a clear and concise way to format your data and format how it must be presented to customers that were affected by the breach. But one thing that this entire form is lacking is how much is required. For example, what happened? You can put "we were breached." You are telling them that you were breached, but you're not going into all the data that they might actually want to know what's going on. So some organizations will go into great depth while some organizations will do the absolute minimum. So while this is a great attempt, we've not gotten completely to where we want to be. So we're kind of halfway there, sideways face. And two other sections of the policy that aren't necessarily addressed directly in this law are the responsibilities and the references. Now with references, it's a law. Laws generally don't have references built into them. And for responsibilities, the entire thing is in itself a responsibility because unlike an enterprise-wide information security policy, we're not addressing every facet of the organization. We're addressing one specific issue that must be addressed by a very unique scope of organizations.
Okay, now we are going to review some real cases. First, we're going to start with the notification delay that in the law is the definition is a little bit vague because it says like in the most expedient time possible and without unreasonable delay. So this definition could be taken by companies, and companies can take advantage of that and take a little bit longer without breaking the law, right? So what we have done is take all the stats from the last 3 years, and we identified that the media it's 30 days. Meanwhile, the mean it's 40 days, right? So that shows that it's possible that some companies are taking too much time making the notifications to the users. But the good thing is like, okay, the 25% of all the breaches are being notified below 16 days. Meanwhile, the 75% of the breaches are notified below 50 days. Now, we can check some notification from Discovery, which is a financial services company. And this breach happened in 2014. At that time, we can see how the title of the notification doesn't say that there was a security breach, right? They only say like for your security, your current Discovery card will be deactivated. It sounds like something went wrong with my car, but it doesn't tell me that actually it was a security breach. In this subtitle, while you are getting a new car, they mention that they have some account information that may have been compromised, but actually it doesn't say exactly which information was compromised, so users cannot take action about this breach. And when they mention about what you need to know, they mention what you need to know in order to resume your credit card service, but doesn't mention anything related with your privacy and how your privacy can be compromised. So we are going to compare this notification with the 2016 notification from the same company. This company has suffered several breaches during the last years, but we can check that in this notification, which happened after the amendment of the law, they say clearly that there was data breach, right? So that's a good thing. And they include all the headings required by the notification. Let's focus on what information was involved. They mention like some car account information was involved, but they don't mention if any PII was involved. And what you can do, they keep saying about what you can do in order to resume your credit service, but not what you should do in order to keep an eye on your privacy. Now we are going to compare it. We are going to compare it with a notification breach that happened in 2016, the same year, which is also after the amendment of the law. And the idea of this comparison is like the law specifies exactly which headings should be included, but doesn't say exactly which information should be included in the headers. So we can see this notice of data breach is from Stanford University, and it says clearly that this is a formal written notice of a possible data breach involving your IRS Form W-2, right? And they say in a detailed way what happened and which information could be leaked in this moment. So users can take action over that, trying to reduce the risk of the privacy, of any privacy leak. Okay, the next breach that we are going to talk about is the Yahoo breach, which happened on September 22 of this year. And we are going to focus on the intended and unintended consequences of the law. So in this notification, we can see that all the headings required are well defined, and the specific information that was leaked is also very, very well defined. However, we can check that in this breach, we have some intended consequences. For instance, we have more than 500 million users notified, which is really good. And right now, those users are aware of the situation and can take an action about their privacy. And we also had some unintended consequences. That the thing that happened is like Verizon was acquiring Yahoo for $4.8 billion, but with this breach, that acquisition value could change, right? And also, the day after the notification, the breach notification, the Yahoo stock went down by a 3.75%, which is something that was not intended to do with the law.
So that's it, guys. We've talked about the policy. We've gone through the sections of good information security policy. We started at the Statement of Management Intent, and we began our journey through Senate Bill 1386. We talked about the gaps and the changes of the law, how at first it was just some very specific PII, and then maybe it was a little bit more, and now it's going to be all encrypted and unencrypted PII. We even talked about some of the real-world implementations. We talked about how the law means for people to be aware, but it doesn't mean that companies should lose value, but that may be one of the unintended consequences of being forced to notify users of this breach. So we hope that you've enjoyed this presentation on Senate Bill 1386 about California's data breach notification law. Thank you very much.